members moved too fast, and by the time they were passing the so-said proposals, later on, that's how members came to you, Honorable Speaker, asking for the CS for transport to come and explain certain things. I think it needs to be given enough time, and those chairmen bring those reports on time so that members and the country understand exactly what we are doing, especially on that issue. Thank you, Honorable Speaker.
Honorable Undo.
Thank you, Honorable Speaker. I just to join or echo the sentiments of my colleague, Honorable Mwalimu. Honorable Speaker, Parliament is a house of debate, and more so, it's given the task of budget making. In the last session of the last year, Honorable Speaker, we have had this tendency of members rising on certain standing order to curtail debate, to an extent that many of the young MPs and the new MPs have not mastered the art and the process and the stages involved in budget making. I do want to urge you, and I want to urge the majority leader and the leadership on that side, and the committee members and any member who's in the speaker's panel, let us do justice to the people of Kenya. Let's allow elaborate and adequate debate on any matters that come before this House. Honorable Speaker, there isn't a very good narrative about Parliament outside there. And on many occasions you have been forced to respond to very snide and bad comments about Parliament. It's time now, we have the opportunity, we have the time to right the wrongs. And I want to urge the leadership on the majority side, allow debate to flourish so that Kenyans can see and feel their Parliament at work. Thank you, Honorable Speaker.
Thank you, Honorable Undo. Honorable members, before I put the question, allow me to acknowledge in the Speaker's gallery Othaya Boys School, I believe, from Othaya constituency in Nyeri. On my own behalf and on your behalf, I welcome the students and their teachers to the House of Parliament. I now put the question, which is that pursuant to the provision of Standing Order 97-1, this House orders that each speech in a debate on the report of the Budget and the Appropriations Committee on Budget Estimates contemplated under Standing Orders 239 and 240, it be limited as follows. General supply debate, a maximum of 3 sitting days with 30 minutes for the mover in moving and 15 minutes in replying. A maximum of 15 minutes for each of the chairpersons of the departmental committees and a maximum of 10 minutes for any other member speaking except that the leader of the majority party and the leader of the minority party, who shall be limited to a maximum of 15 minutes each. And that priority in speaking be accorded to the leader of the majority party, the leader of the minority party, and the respective chairpersons of the departmental committees in the order that they appear in the second schedule to the standing orders. And 2, the Committee of Supply, a maximum of 6 sitting days for the consideration of the proposed allocations to the respective votes and programs in the order specified in the schedule submitted by the Budget and Appropriations Committee. Thank you. Sorry, as members of that opinion say aye. Aye. Will those of the contrary opinion say nay? The ayes have it. Honorable Bayer and the Chair of Budget, you've heard the sentiments of members. Bring the reports early for members to be able to go through. And we assure you, Honorable Undo, that the Chair does not truncate debate. It's entirely up to the House. When the House, through any member, moves a closure, the only avenue available to the Chair is to put it to the House. If the House says truncate the debate, it's truncated. If you reject it, you go on. So always, if you feel there's inadequacy of debate, marshal your members to reject any truncating of debates. Thank you. Next order.
Order number 11, procedural motion. Limitation on debate on consideration of Senate amendments to bills originating in the National Assembly.
Majority Leader.
Thank you, Honorable Speaker. Honorable Speaker, I would like to encourage first Honorable Oundo that we agreed in the morning to follow your guidance on candor and banter.
Yes.
And therefore, we will go by that to ensure that debate flourishes in this chamber and that members can see and your constituents can see that you're doing what they elected you to do. So we promise that this side we will not truncate debate. Thank you, Honorable Speaker. I beg to move the following motion that pursuant to the provisions of Standing Order 97.1, this House orders that each speech in the general debate contemplated under Standing Order 146, consideration of Senate amendments to bills originating in the National Assembly, be limited as follows. A maximum of 1 hour and 30 minutes with not more than 15 minutes for the mover in moving, 15 minutes for the chairpersons of the relevant departmental committee, and 5 minutes of any other member speaking, including the leader of the majority party and the leader of the minority party, if the bill is not party-sponsored, and that 5 minutes before the expiry of the time, the mover shall be called upon to reply, and further, that priority in speaking shall be accorded to the leader of the majority party and the leader of the minority party and the chairpersons of the relevant departmental committee in that order. Honorable Speaker, I request the Honorable Junaid Mohammed to second.
Mr. Speaker, I stand to second, but I wanted to say also that, Mr. Speaker, the 5 minutes, normally, because of the interest that is shown always by members in the debate, so normally sometimes reduced to 3 minutes, 2 minutes. So I know it's because of the interest, not because of the speaker, that's shown by many members who want to speak to it. But let's see if we can increase the time on that bill, the time of debating, the period that the bill still stays in the House for debating. But otherwise, I second, Mr. Speaker.
Honorable Junaid, before I propose the question, you know, in comparable jurisdictions, you as the whips, when you have such technical debates on motions such as budget, appropriations, is within your competence as the whips to actually give the speaker a few of your preferred sharpshooters who can articulate issues. The leader of majority can approach the chair and say, on this particular issue, our best economists to articulate the issues include so and so, so and so. We'll still give others, but we also abide by your opinions as whips. On your side also, if you have people who have better knowledge and schooling in economics, in accounts, and in matters relating to budget, the chairs will always give you priority to give 1 or 2, 3 well-schooled members who can then give better opinions to the House to inform debate. So it's entirely up to you also to decide how you assist the chair, so that once you have all those that you prefer, and don't bring lists of your friends, bring lists of people who add value to debate. Then thereafter, we can limit to 2 minutes to each other member to complement what your sharpshooters have already placed on the floor. This is done in the House of Commons, everywhere, in Australia, in Canada, in the entire Commonwealth jurisdiction. So it's not strange to this country. I'm not proposed the question. I was just guiding Honorable Junaid in his lamentation. Honorable members, I now propose the question, which is that pursuant to the provisions of Standing Order 971, the House orders that each speech in the general debate contemplated under Standing Order 146, consideration of Senate amendments to bills originating in the National Assembly, be limited as follows. A maximum of 1 hour and 30 minutes with not more than 15 minutes for the mover and moving, 15 minutes for the chairperson of the relevant departmental committee, and 5 minutes for any other member speaking, including the leader of the majority party and the leader of the minority party if the bill is not party-sponsored, and at 5 minutes before the expiry of the time, the mover shall be called upon to reply, and further, that the priority in speaking shall be accorded to the leader of the majority party, the leader of the minority party, and the chairperson of the relevant departmental committee in that order. I put the question? Yes, Honorable Pukose and KJ, you'll follow.
Thank you, Honorable Speaker. Honorable Speaker, I just wanted to remind my colleagues, Honorable Undo, that as much as the House is for debate, but we have a legislative role that we must also play. That at various stages, there is a bill when it is in maybe in the second reading where we need to be able to debate it. Then you have a stage where you have the committee of the whole House when we are supposed to be legislating. So we should also be able to understand and give preference in as far as at times when when we move understanding order 95 that the mover be called to reply or that kind of thing, that to bring the debate to an end. Because we also want to be able to make that law into place. And at times even time might be running out. So there are all many other considerations. And we'll ask that both our sides, we are able to listen to each other, we are able to debate, and be able to defend our positions. Thank you, Honorable Speaker.
KJ?
Mr. Speaker, I truly thank you, and I take this opportunity to wish you a happy new year, and also congratulate you and the clerk of the National Assembly for amazing work that happened in this parliament during the recess. That said, Mr. Speaker, I'm standing to support this procedural motion because this is one of the opportunities that this House gets to showcase its prowess, even against its sister chamber, which is the Senate, where you served, Mr. Speaker. Whenever Senate returns some amendments to this House, these debates are normally so critical, Mr. Speaker, because at that point, this House is able to showcase its level of debate, its level of transaction of business, and able to even showcase itself as the true upper house of this bicameral parliament, Mr. Speaker. But Mr. Speaker, the big observation that I needed to make is that this afternoon is a perfect example of how you end up being appropriated issues that are not concerned to your chair. This is a day that we are making procedural motions and dictating how much time we are allocating to specific motions. But you can see how the parliament is populated, how the chamber is populated. And later on in the session, we shall get into problems with members of parliament appropriating some responsibilities that do not belong to the chair to you, Mr. Speaker, saying that you're appropriating time. But when the business was being conducted, these members were actually not in chamber. So, Mr. Speaker, it is again calling upon the whips of this House to actually whip the members of the different parties, Mr. Speaker, so that they are present when very serious business is happening, up to and including, Mr. Speaker, what looks like mundane business, like procedural motions, up to and including, Mr. Speaker, what we call the omnibus bills, where we suffer quorum hitches because of mobilization of members to participate in very important debate. Mr. Speaker, I support the procedural motion. I'm okay with the time appropriated. Thank you very much, Mr. Speaker.
Great. I now put the question that pursuant to the provisions of Standing Order 971, this House orders that each speech in the general debate contemplated under Standing Order 146, consideration of Senate amendments to bills originating in the National Assembly, be limited as follows: a maximum of 1 hour and 30 minutes, with not more than 15 minutes for the mover in moving, 15 minutes for the chairperson of the relevant departmental committee, and 5 minutes for any other member speaking, including the leader of the majority party, the leader of the minority party if the bill is not party-sponsored, and that 5 minutes before the expiry of the time, the mover shall be called upon to reply, and further that priority in speaking shall be accorded to the leader of the majority party, the leader of the minority party, and the chairperson of the relevant departmental committee in that order. As many as of that opinion say aye. Aye. Will those of the contrary opinion say nay? The ayes have it. Next order.
Order number 12, procedural motion, consideration of business received during the recess periods.
Majority Leader.
Thank you very much, Honorable Speaker. Honorable Speaker, I beg to move that, notwithstanding the provisions of Standing Order 41 and 42 relating to conveying of messages from the Senate and from their President of the National Executive, Standing Orders 120, 122, and 126 relating to publications, procedure upon publication and first reading of bills, and Standing Order 210-2 relating to tabling of statutory instruments, this House orders that during the short and long recess of the third session, 1, upon receipt of any message from the Senate or upon receipt of any name of a person nominated for appointment to a state or public office from the President or any other office in the National Executive, the Speaker shall forthwith refer such messages to the relevant committee for consideration without having to recall the House and report such fact to the House on resumption. 2, upon receipt of any message relating to the Senate's amendment to a bill originating in the National Assembly, the Speaker shall forthwith refer the schedule of the Senate amendment to the relevant committee for consideration pursuant to the provisions of Standing Order 145, Senate amendments to bills originating in the National Assembly, and report such fact to the House on resumption. 3, should a bill be published during the said period or a published bill become due for first reading, the Speaker shall, upon lapse of at least 3 days following the publication of the bill and following a determination that such bill is of priority, forthwith refer such bill to the relevant committee for consideration pursuant to the provisions of Standing Order 127, Committal of Bills to Committees and Public Participation, and cause the bill to be read a first time upon its next sitting, and the second reading may be taken forthwith or on such other day as the House Business Committee may determine. 4, should any statutory instruments be transmitted for tabling before the House during the period, Speaker shall, following a determination that the statutory instrument is of priority, forthwith refer the statutory instrument to the relevant committee for consideration and cause the statutory instrument to be tabled in the House upon its next sitting in accordance with the provision of Section 2 of the Statutory Instruments Act number 3 of 2013. And 5, should any paper be transmitted for tabling before the House, the Speaker shall, following a determination that the paper is of priority, forthwith refer the paper to the relevant committee for consideration and cause the paper to be tabled in the House upon its next sitting. Honorable Speaker, I think this is very clear. It concerns issues that are brought to the House when we're in recess or we are on any other, when the House is not sitting. And therefore, the procedure is laid down very, very clearly. And I would like to request the Honorable Junet Mohammed, the whip, long-serving whip of the minority, to second.
Mr. Speaker, as I second, I wanted to bring to your attention, Mr. Speaker, this procedural motion was introduced to this House, I think the year 2014 or 15, the House here. And Mr. Speaker, it was basically to make the work of the executive easy. Because that time, Mr. Speaker, as you remember, as a long-serving member of Parliament, you know that vetting of appointments never used to happen before the new constitution came into place. So a time arose when appointments were made when we are either in short recess or long recess or those kind of things. Then the executive felt that Parliament is wasting their time. So they persuaded Parliament to do this kind of procedural motion. But Mr. Speaker, as you know very well, we also have the provision in the standing order of a special sitting. If something is so important and so urgent, we have a provision in the standing order that says the House can be reconvened by the Speaker. So if there are 1 or 2 appointments that are of important and urgent in nature, there is no harm in reconvening the House to come and sit and deliver. Because the issue of appointments coming through the Speaker and the Speaker doing it in communication, Mr. Speaker, doing the communication on the floor of the House, Mr. Speaker. Mr. Speaker, I was saying the issue of the appointment.
I was listening, go on.
Yeah, coming through the Speaker and the communications being made on the floor of the House, Mr. Speaker, carried its own weight, Mr. Speaker. Then when those documents and papers are just committed to committees silently, and then later we come, Mr. Speaker, in spite of all those lamentations, I second.
Thank you, Honorable Junet. It's within your competence to revisit the standing orders and revert to whatever you prefer. But for now, I propose the question that notwithstanding the provisions of Standing Order 41 and 42 relating to conveyance of messages from the Senate and from the President or the National Executive, Standing Order 120, 122, and 126 relating to publication, procedure upon publication, and first reading of bills, and Standing Order 210-2 relating to tabling of statutory instruments, this House orders that during the short and long recess of the third session, 1, upon receipt of any message from the Senate or upon receipt of any name of a person nominated for appointment to a state or public office from the President or any other office in the National Executive, the Speaker shall forthwith refer such message to the relevant committee for consideration without having to recall the House and report such fact to the House on resumption. 2, upon receipt of any message relating to the Senate's amendment to a bill originating in the National Assembly, the Speaker shall forthwith refer the schedule of the Senate amendments to the relevant committee for consideration pursuant to the provision of Standing Order 145, Senate amendments to bills originating in the National Assembly, and report such fact to the House on resumption. 3, should a bill be published during the said period, or a published bill become due for first reading, the Speaker shall, upon lapse of at least 3 days following the publication of the bill, and following a determination that such bill is of priority, forthwith refer such a bill to the relevant committee for consideration, pursuant to the provisions of Standing Order 127, Committal of Bills to Committees and Public Participation, and cause the bill to be read a first time upon its next sitting, and the second reading may be taken forthwith, or on such other day as the House Business Committee may determine. 4, should any statutory instruments be transmitted for tabling before the House during the period, the Speaker shall, following a determination that the statutory instrument is of priority, forthwith refer the statutory instrument to the relevant committee for consideration and cause the statutory instrument to be tabled in the House upon its next sitting in accordance with the provision of Section 11 of the Statutory Instruments Act number 3 of 2013. And 5, should any paper be transmitted for tabling before the House, the Speaker shall, following the determination that the paper is of priority, forthwith refer the paper to the relevant committee for consideration and cause the paper to be tabled in the House upon its next sitting. Robert Mbui.
Thank you, Mr. Speaker. I also rise to support this procedural motion, but I wanted to point out one matter here on part 4, the one on statutory instruments. Mr. Speaker, it's important to note that regulatory making authorities that make regulations pursuant to the bills that we pass in the House, sometimes within the statutory instruments, within the gazettement, may even be imposing charges on the general population. And so I've noticed it has been a tendency sometimes for the executive to wait just before the House goes on the recess is when they publish some of these very, I would say, punitive regulations. And Mr. Speaker, the danger would face is that if we go on a recess of 2 months, is that then this, the imposition of these levies or fees would proceed, because the minute the gazettement takes place, already the regulations become law. Until the Committee on Delegated Legislation of the House is seized of the matter and deliberates on it, and in case the committee decides that they are too punitive and have to be annulled, then they would have to wait until the House sits. That's when they would present them. So I feel that everything else makes a lot of sense, but we may also be careful that we don't now allow the executive to make laws, collect taxes for, or levies for 2 months, and then a House makes a decision when already, you can say the horses have bolted. So I support, but I think it's important to figure out how to handle that part on statutory instruments. Thank you, Mr. Speaker.
Yes, Owen?
Honorable Speaker, I think it's what Honorable Mbui has raised is very important. And I think we saw a flagrant of statutory instruments being put out there during the long recess. And I think as a House we need to, because nobody can make law apart from Parliament, and we think we need to put that. But having said that, I think we have a great opportunity because the statutory law amendment bill is coming in. I think it will be read first reading today without any debate. But it's important that those things are captured so that we can actually stamp our authority in terms of lawmaking as Parliament. I thank you, Honourable Speaker.
When by the leadership, you should advise all government departments, ministries, and statutory bodies that they have no capacity to turn anything into law until and unless it has passed through this House. Even this number 4 simply says once it comes here, it still remains a proposal until it's processed through the committee, brought to the floor, and adopted by the House. That's when it becomes a legal instrument with a force of law. And besides that, if then there are any other issues like taxation, levies, and whatever, the committees must do their work and sieve them out. I can now put the question. Honourable members, I now put the question that notwithstanding the provision of Standing Order 41 and 42 relating to conveying of messages from the Senate and from the President or the National Executive, Standing Orders 120, 122, and 126 relating to publication, procedure upon publication and first reading of bills, and Standing Order 210, 2 relating to tabling of statutory instruments, this House orders that during the short and long recess of the third session, 1, upon receipt of any message from the Senate or upon receipt of any name of a person nominated for appointment to a state or public office from the President or any other office in the National Executive, the Speaker shall forthwith refer such message to the relevant committee for consideration without having to recall the House and report such fact to the House on resumption. 2, upon receipt of any message relating to the Senate's amendment to a bill originating in the National Assembly, the Speaker shall forthwith refer the schedule of the Senate amendments to the relevant committee for consideration pursuant to the provisions of Standing Order 145, Senate amendments to bills originating in the National Assembly, and report such fact to the House upon resumption. 3, should a bill be published during the said period or a published bill become due for first reading, the Speaker shall, upon lapse of at least 3 days following the publication of the bill and following a determination that such bill is a priority, forthwith refer such a bill to the relevant committee for consideration pursuant to the provision of Standing Order 127, Committal of Bills to Committees and Public Participation, and cause the bill to be read a first time upon its next sitting, and the second reading may be taken forthwith or on such other day as the House Business Committee may determine. 4, should any statutory instruments be transmitted for tabling before the House during the period, the Speaker shall, following the determination that the statutory instruments is of priority, forthwith refer the statutory instrument to the relevant committee for consideration and cause the statutory instrument to be tabled in the House upon its next sitting in accordance with the provisions of Section 11 of the Statutory Instruments Act number 3 of 2013. And 5, should any paper be transmitted for tabling before the House, the Speaker shall, following a determination that the paper is of priority, forthwith refer the paper to the relevant committee for consideration and cause the paper to be tabled in the House upon its next sitting. As many as of that opinion say aye. Will those of the contrary opinion say nay? The ayes have it. Next order.
Order number 13, procedural motion, limitation on debate on legislative proposals to amend the Constitution.
Majority Leader.
Thank you, Honourable Speaker. Honourable Speaker, I beg to move that pursuant to the provision of Standing Order 97.1, this House orders that each speech in the general debate contemplated under Standing Order 1147A and B, consideration of the legislative proposal to amend the Constitution be limited as follows. A maximum of 20 minutes for the mover in moving and 10 minutes in replying, 15 minutes for the leader of the majority party and the leader of the minority party if the proposal is not party-sponsored. Members with similar or related proposals and the chairperson of the relevant department committees, and 10 minutes for any other member speaking, and further that priority in speaking shall be accorded to the leader of the majority party and the leader of the minority party and the chairpersons of the relevant departmental committee in that order. Honorable Speaker, I request that I ask Dr. Mutunga to second.
Thank you, Honorable Speaker. Honorable Speaker, constitutional amendment is a very key issue in this country, and I believe the way the time has been apportioned is crucial because it will allow most of the members to contribute. Therefore, I second.
Honorable members, I now propose the question, which is that pursuant to the provision of Standing Order 97-1, this House orders that each speech in the general debate contemplated under Standing Order 114-7AB, consideration of a legislative proposal to amend the Constitution, be limited as follows: a maximum of 20 minutes for the mover in moving and 10 minutes in replying, 15 minutes for the leader of the majority party and the leader of the minority party if the proposal is not party-sponsored, members with similar or related proposals and the chairperson of the relevant departmental committee, and 10 minutes for any other member speaking, and further that priority in speaking shall be accorded to the leader of the majority party, the leader of the minority party, and the chairperson of the relevant departmental committee in that order. Now put the question. Before I put the question, honorable members, allow me to acknowledge in the speaker's gallery, seated in the upper echelon, believe these are students from PCEA Mitahato Secondary School, Githunguri, Kiambu. On my behalf and on behalf of the House, I welcome the students and their teachers to the House of Parliament. I'll now put the question, which is that, pursuant to the provision of Standing Order 97-1, this House orders that each speech in the general debate contemplated under Standing Order 1147-AB, consideration of a legislative proposal to amend the Constitution, be limited as follows: a maximum of 20 minutes for the mover in moving and 10 minutes in replying, 15 minutes for the leader. Yes, majority.
Thank you, Honorable Speaker. I was checking whether the chair of the Budget and Appropriations Committee is in the House, because in most instances, and I know, for instance, the case for the PFM amendment, because it will have some implication on being a money bill proposal, they will usually lie in the Budget and Appropriations Committee, and the Honorable John Buddy, having been my member when I was the chairman of the Budget and Appropriations Committee, will remember that at least every 2 months or so, we would appraise the House on the status of any legislative proposals, and I will pick that up with the chair of the Budget and Appropriations Committee to be giving us an update, actually not even to my office, an update to the House on members' legislative proposals, where they are, those that have money bill effect and those that have gone through the Budget and Appropriations Committee. And of course, even others that may not have a money bill effect, but have got to go through the departmental committees. We will liaise through the liaison committee, Honorable Speaker, to make sure that we occasionally update the House so that members' members don't go through the rigors of making proposals and they never get to see the light of day to get an opportunity to be debated. Especially that one on Article 223, Honorable Speaker, I think we will need to follow up because it's a very critical issue in the management of our finances in this country and the abuse that has been there previously of the use of Article 223. Thank you.
Thank you. Next order.
Order number 8, the Affordable Housing Bill, National Assembly Bill number 75 of 2023, second reading.
Majority Leader. Who has a point of order? Yes, Junet.
Mr. Speaker, thank you for your indulgence. Mr. Speaker, yesterday we were here for debate the whole day, and we took time to debate the motion that you approved on femicide. And in the middle of the motion is when the report for this bill was presented by the chair of the committee, the speaker. And it's only a night that has passed. And I'm sure people have other businesses that they conduct at night, especially on a Valentine Day, Mr. Speaker, especially on a Valentine Day. I'm sure, Mr. Speaker, people are not conversant with the report of the committee and how it has gone. So, Mr. Speaker, I was seeking your indulgence if more time can be given, even over the weekend, so that people can read, so that we see how housing affects everyone and how we are, Mr. Speaker, Parliament has conducted a thorough public participation this time. They have gone to every part of the country, and they have listened to the people's views, and those views are contained in this report. So we need time to look at them and analyze them and internalize it. Then from there we say, this is, In the meantime, we could debate issues like NADCO now, for example. Then we come to housing after that. Thank you, Mr. Speaker.
Majority.
Thank you, Honorable Speaker. You know, the Honorable Junet is my good friend, and I know his wife. So when he talks about Valentine's, Honorable Speaker, I know Junet's wife allowed him adequate time to go through the report, even as he did the other things that pertains to Valentine's. And it's true, Honorable Speaker, that report was tabled yesterday afternoon. That is exactly almost 24 hours since it was tabled. And members, I'm certain, have had the opportunity to peruse through the report. And more importantly, Honorable Speaker, what I am moving for debate is the bill, not the report. The report only serves to inform what the work that the committee has done. And I agree with the Honorable Junet that the joint committee that you designated to handle this bill, Honorable Speaker, has done very good work and done extensive public participation in line with our Constitution. And therefore, Honorable Speaker, ask that you allow me to continue, go ahead and move debate for the second reading of the bill.
Proceed.
As members. Thank you, Honorable Speaker. Honorable Speaker, I therefore beg to move.
On the same point? On a different issue? Yes.
Just for good order.
Yes, Honorable
Yes.
Wandai.
Yes, I think maybe this is the best time to raise this issue with you so that we move on the same wavelength. Honorable Speaker, if you look at the bill that is currently before us, you will notice clearly at page 2133 that the bill has been characterized as a bill not concerning counties. Okay? And I want you to allow me, just to indulge me for one second, to read that particular paragraph. That the bill relates to the broader policy framework on housing, with particular emphasis on so on and so forth, and therefore it does not concern counties within the meaning of Article 110 of the Constitution. Honorable Speaker, I need your guidance here, really, because I feel that I am lost. Because if the promoter of the bill contends that the bill does not concern counties, that it simply delves into matters housing policy. No, I am raising a fundamental issue that needs to be addressed before the debate can even commence. It's very critical here. And if you go to Schedule 4, Honorable Speaker, Schedule 4, the fourth schedule of the Constitution, indeed, housing policy is a function of the national government at Sub-Article 20. But again, if you go there then to the functions of the county governments, you will find at paragraph 8, one of the functions of the county governments is county planning and development, including, among many other things, at Part D, housing. Mr. Speaker, this is a matter that requires your guidance, because if you say, therefore, that this bill is only dealing with housing policy, and you go to the memorandum of objects and reasons, Mr. Speaker, a casual glance at the memorandum and objects of this bill clearly tells you, even if you are a layman, that this bill goes beyond policy. It goes beyond policy. It delves into serious matters of housing that affects the counties directly. In fact, it even has consequential amendments to the Employment Act. It has got serious issues. It even establishes a board that will manage the funds. It goes on and on to determine how these funds will be raised and even the eligibility criteria for these houses. So in a nutshell, Honorable Speaker, I want to really take more time than this. If you go to the Article 110 of the Constitution, very finally, Article 110 of the Constitution, and thank you for indulging me, Honorable Speaker. It wasn't my wish to interrupt my good friend, Honorable Chungwa. In this Constitution, I'm reading it verbatim, Honorable members. In this Constitution, a bill concerning a county government means, among other things, a bill containing provisions affecting the functions and powers of the county governments set out in the 4th schedule, and so on and so forth. But then it goes ahead to say at Article 1113 that before either House considers a bill, the Speakers of the National Assembly and Senate shall jointly resolve any question as to whether it is a bill concerning counties, and if it is, whether it is a special or an ordinary bill. What am I saying? That the House needs to be guided by your chair, Honorable Speaker, whether that consultation between yourselves and Article 1113 has taken place, and you've resolved that this bill is a bill that doesn't concern counties, and therefore doesn't have to go to the Senate. That has to be clarified. Because from where I stand, I hold a strong view, a very strong view, that in the manner this bill has been structured, this bill clearly affects counties, and therefore it is improperly characterized. That is my point. It is improperly characterized, and that improper characterization must be corrected before we can proceed to the stage of moving it. Thank you. I submit.
Majority, you have some. Majority.
Thank you, Honorable Speaker, and I agree with the leader of minority to a large extent that there is no doubt that this bill concerns counties. And therefore, Honorable Speaker, first, the courts, Honorable Speaker, have already held that before first reading, there is no need for concurrence on whether the bill is one that concerns counties or not. Two, Honorable Speaker, it is up to you as speakers, between yourself and the Speaker of the Senate, to agree on whether a bill concerns counties or whether it will go to the Senate, or that is coming to the Senate will need to come here. Therefore, Honorable Speaker, I believe between the two offices of the speakers, you must have consulted and you will be able to guide us. However, Honorable Speaker, the import of what was in the memorandum, Honorable Speaker, was largely informed by what is in the text of the objects, as Honorable P was reading on page 2133, on the broader policy framework and the money bill aspect of the bill. But Honorable Speaker, even as a committee, and that's why we had a joint committee, the Committee of Housing and Finance, engaged with stakeholders, it became clear that there are certain aspects of the bill that will require this bill to go to the Senate, and I am certain the leader of the majority in the Senate is already waiting for us to do justice to this proposal, and it will go to them eventually, as at when, Honorable Speaker, yourself and the Speaker of the Senate do agree. And And therefore, Honorable Speaker, I would want to beg that we still go ahead and do what we ought to be doing now, debating, because some of the issues I've had the Honorable Pio speak to are issues actually that he should be speaking to during debate. And therefore, we are just preempting debate before we move. And you allow me to move, and we will have all the time today, tomorrow, if we want to sit tomorrow, on Tuesday afternoon, on Wednesday afternoon, and morning, if we desire to, Honorable Speaker, to be able to debate all these issues. Therefore, Honorable Speaker, I want to beg your indulgence that you do allow me to move the bill, call a seconder, and then we open debate, and we can debate onto all those issues that we want to debate on, including whether this bill will enable us to build houses in all the counties that we went for public participation to.
Order. I'm not opening debate on this. I want to give you the following guidance. The minority leader and the majority leader, you're both right. This is a bill that concerns counties. Number two, Article 110.3 was complied with. The speakers of both houses exchanged communication, and we were in concurrence that this is a bill that concerns counties. So from here, the bill will go to the Senate. Number three, the misdescription in the memorandum and objects of the bill is something curable. Yeah. In any event, at the end of the passage of this bill, the memorandum and objects of, and reasons of the bill are mere descriptions. They will not become part of the act that you'll eventually pass. Yeah. The content is in the clauses in the bill. Yes. So at the time you go to committee stage, you can very well, for purpose of aligning the bill in the line of the arguments of the minority leader, amend the memorandum and objects and remove any offending words for purposes of record, and for purposes of record only, and nothing else. This bill concerns counties. From here, it will go to the Senate. Proceed, Majority Leader. Very good.
Thank you, Honorable Speaker, for that guidance. And indeed, the memorandum is just that, a memorandum. It's a storyline that tells you what the bill is about. But Honorable Speaker,
that matter is rested.
Yeah, I know, Mr. Speaker. No, Mr. Speaker.
Yes.
For purposes of tidiness, to tidy up, because, you know, these bills, Mr. Speaker, after we finish with them here, there are other people who deal with them and take them to elsewhere. So we can debate on this bill based on your ruling that the memorandum, the definitions in the memorandum and objects have been expunged or something like that. Otherwise, Mr. Speaker, somebody will use the bill that as of when it was being moved at the second stage, it says that this bill does not concern counties. It's as period as that. So if the Speaker has made a ruling that I have used standing order number 1 and have expunged that definition, then, Mr. Speaker, we are safe. But otherwise, we are debating a defective bill because, Mr. Speaker, the memorandum and objects inform the article.
Order, Junet. You are overstretching your imagination. What the chair has directed automatically becomes an addendum to what you will eventually decide. So the matter rests there. Let's have the majority leader move the bill.
Thank you, Honorable Speaker. Honorable Speaker, I therefore beg to move that the Affordable Housing Bill, National Assembly Bill number 75 of 2023, be now read a second time. Honorable Speaker, maybe for the comfort of Honorable Junet, I will repeat once again that this bill, as moved, concerns counties, and if approved by the House, will find its way to the Senate. Honorable Speaker, allow me to begin by first thanking the chair of the Housing Committee, the Honorable Ngeno, who is here, the Honorable Kimani Kuria, our chair of the Finance Committee, who, together with their members, their 30 members, Honorable Speaker, spent a considerable amount of their recess time going around 19 out of our 47 counties in a very extensive public participation that they conducted throughout the country, listening and consulting a wide cross-section of stakeholders and technical experts by way of public hearings, as I mentioned, in 19 counties, Honorable Speaker, including the county of Nairobi and in Parliament. Honorable Speaker, this committee has done a commendable work, and they have indeed, as I mentioned when responding to the point of order, done a lot of justice to this bill. Honorable Speaker, bills as proposed are mere legislative proposals and therefore require the input of our committees. And that's why I take a lot of time to thank the committee, because they have done a lot of invaluable work. They consulted very many experts, from experts in the housing sector to finance experts, and even ordinary Kenyans, Honorable Speaker, who are potential beneficiaries of the housing, this housing agenda and the housing bill, and including, Honorable Speaker, potential contributors to the fund. And we saw Kenyans coming out to agree with the court that indeed the levy, the housing levy, as it were in the Finance Act, had discriminated against some who want to contribute. And I was impressed when I saw on TV Kenyans coming out to say that they want to contribute to this fund because they understand its input in our national development and in the job creation endeavor of our country. Appreciating, Honorable Speaker, that there are millions of young Kenyans across the country who have no jobs. Kenyans from many walks of life, including people who are in self-employment. Honorable Speaker, I saw some market traders. I don't remember whether they were from Karioko, the chair finance or chair housing would have reminded me, who appeared before the committee and asserted that they would want to actually find a mechanism to be able to contribute to the fund, not only to be able to access housing as a constitutional right under Article 43 of our Constitution, but also to offer other young Kenyans and other unemployed Kenyans an opportunity to access job opportunities. Honorable Speaker, we saw many professionals, architects, engineers, lawyers, accountants who appeared before the committee, the two committees, contending that the job creation agenda that comes with this housing agenda is not just what has been said in political rallies and in funerals, that it's about what we call watu ya mkono in construction sites and fundis. That, Honorable Speaker, architects, quantity surveyors, engineers from civil, electrical to water engineers are accessing huge opportunities in jobs that are being created by this agenda. And many Kenyans express the desire and the need to have a legal framework, Honorable Speaker, that would actualize this housing agenda. Therefore, Honorable Speaker, if you go to the objects of the bill under Article 3, one, it is envisaged, Honorable Speaker, that this bill, once it becomes an act, will have three key objectives. One is to give effect to Article 43 of our Constitution, 43(1)(b), on the right to accessible and adequate housing. And, Honorable Speaker, for members like Honorable Junet, who took time last night to go through the committee's report, they will see the committee has indeed also proposed an amendment to include the words to reasonable standards of sanitation, so that we don't just have provide affordable housing, but housing that has, in the words of our Constitution, reasonable standards of sanitation. Two, Honorable Speaker, the second objective is to impose a levy to facilitate the provision of affordable housing. And C, or three, is to provide a legal framework for the implementation of the housing programs and projects. Honorable Speaker, this is one of the areas that the courts found wanting in what was passed during the Finance Act. The courts did advise at least two important things. That one, they lacked a legal framework, and that is what now this new proposed legislation intends to do, to create that legal framework for the implementation of the affordable housing programs and projects. That now, under this act, Honorable Speaker, will have that legal framework that the courts found as not having had one. Although, Honorable Speaker, I had a problem with that particular finding of the court, as much as, Honorable Speaker, I don't want to get into issues that could be sub judice. Because, Honorable Speaker, when we talk about a legal framework on implementation of a government program, Honorable Speaker, The Appropriations Act that we passed, Honorable Speaker, created that legal framework on how you appropriate funds to implement government projects, including the housing agenda. Honorable Speaker, as I said, I don't want to get into legalese that would be on the verge of getting into sub-judice issues. We leave it to the lawyers in the Court of Appeal. Honorable Speaker, the second issue that was raised by the courts was the issue of the levy that we are creating under the second object, the imposition of a levy to facilitate the provision of affordable housing. The courts did find that the levy that was imposed under the Finance Bill or the Finance Act of 2023 was, in their words, discriminatory and unconstitutional in the sense that it only levied this levy against or on people who are salaried. Honorable Speaker, in this new law, we have now made it possible for even people who are not salaried to be able to contribute. And Honorable Speaker, as I said, I was impressed to see very patriotic Kenyans coming out before the committee saying that they actually not only want to be beneficiaries of the houses that will be built, but they want to be contributors to the fund. They want to pay their fair share, just like those people who are employed or who are salaried. And Honorable Speaker, we must continue to encourage these very patriotic Kenyans who have come out to say that they want to contribute to this fund. Therefore, Honorable Speaker, if you look at, for those who cared to go through the committee's report, they will see also that under Clause 4, where that's providing for the imposition of the affordable housing levy at the rate of 1.5% of the gross salary of an employee or gross income of a person, and that person is a legal person, so therefore could be an individual or a business entity or a company. Honorable Speaker, there existed a lacuna in this Clause 4 of the bill where companies or employers who have already deducted and remitted a matching amount of the levy for its employees were again subjected to pay the levy again on their own gross income. And Honorable Speaker, the committee has made certain recommendations that will cure this lacuna, that if you are collecting as an employer, then you again will not be levied the same on your gross income. The committee also, Honorable Speaker, has provided safeguards in the amendments on that question that the courts did ask on whether the levy was discriminatory, if it is only levied on people who are salaried. The amendment that the committee is proposing, Honorable Speaker, has cured this matter in Clause 4 again by providing that apart from the salaried persons, in Clause 4A, the gross income of a person in the informal sector under Clause 4B is also subjected to this levy. However, Honorable Speaker, the bill was silent also on the mode of collection of this by whoever will be the collector of this levy, and in this case, KRA, Honorable Speaker. And the committee again has sought to cure this. And in the amendments that will be coming during the third reading, the committee will be introducing an amendment that will allow the use of the provision of the Tax Procedures Act of 2015 to apply also for this levy, such that the same way, Honorable Speaker, for income tax, that for us who are employed and salaried, Honorable Speaker, we pay as we want. And this is deducted by our employers and remitted by the 9th of every month to KRA. But for people who are self-employed or people who are in the informal sector, Honorable Speaker, on a monthly basis, on a quarterly basis, they do their installment taxes, and they have the options whether you want to pay installment tax, whether you want to pay advance tax, whether you want to pay your tax at the end of the year. Honorable Speaker, now it will be an obligation that every Kenyan who is earning an income contributes to this fund, and through the Tax Procedures Act of 2015, they will be required then to make their tax returns to KRA and show how they will pay their housing levy, Honorable Speaker. This, in a way, Honorable Speaker, let me, for good manners, take this opportunity to thank the courts, because they have actually made it possible now for government to collect more money. Government initially was to collect only from the salaried people, but we shall now be able to collect more money. in a fund that was envisaged to collect probably 63 billion shillings, we should now be able to collect more money and therefore be able to roll out more projects across the country in all our 47 counties and in all our 290 constituencies. And Honorable Speaker, I will want to take this opportunity to encourage those members of parliament who have not complied with the memoranda or the letter that was sent by the Principal Secretary in charge of housing to propose sites for construction of this affordable housing in your constituencies. Honorable Speaker, I am a beneficiary of this project in Kikuyu, and I can tell you, in a project where we are doing about 755 or 757 houses between us and our neighbors, Kabete constituency, we are projecting to employ close to 2,000 people on site directly and many others indirectly, Honorable Speaker. Honorable Speaker, you remember I was with you the other day when we passed by a site in Kakamega town. And you remember what those young men and young ladies at that site told us, that we should go and tell those people in Nairobi who are talking ill of these housing projects to know that that is where they are earning their daily bread. That is where they are educating their children from. That, Honorable Speaker, the suppliers of steel in these housing projects, Honorable Speaker, suppliers of cement, timber traders, Honorable Speaker, across this country today are not able to satisfy the demand for timber. I have a friend who trades in timber from Congo. He's telling me they are now struggling to get transport to transport timber from as far as Congo, Tanzania, Honorable Speaker, because of the huge demand of timber, of marine boats, of steel in this country today, Speaker. Honorable Speaker, the factory that His Excellency the President commissioned last year, but one, in Mariakani, in the coast, and those members from the coast, the factory owned by, I think it's Devki Steel Mills. That factory today, Honorable Speaker, is unable to satisfy the demand for steel today in this country, Honorable Speaker. Courtesy of these projects, Honorable Speaker. And it's not just about steel, cement, timber, and all the other auxiliary items that get into construction, Honorable Speaker. The huge opportunities that exist in job creation, Honorable Speaker, is what each one of us today here ought to be speaking to. There is none of us, Honorable Speaker, back in our constituencies